The content of this recorded material focuses on the discussions in terms of when absolutions from the instance can be ordered and the requirement for such order. Absolution, one thing we should understand actually is from the instances is a judgment that may be given either at the end of the case or immediately after the close of the plaintiff case. Absolution in this matter actually is granted at the end of the case if neither the plaintiff nor the defendant has put forward sufficient evidence that is declared to secure the judgment in their favor. Rule 100 of the High Court sets out the relevant requirements to be considered when it comes to the absolutions. And for the absolution to be granted, there is a certain test actually which is said to be granted by the court, in which the test of absolutions to be applied by a trial court at the end of the plaintiff's case was formulated in the case of Claude Neo-Light, it's a South Africa versus Daniel of 1976, whereby the court stated as follows: when absolution from the instances is sought at the close of the plaintiff case, the test to be applied is not whether the evidence led by the plaintiff established what would finally be required to be established, but whether there is evidence upon which the court, applying its mind reasonably to such evidence, could or might find for the plaintiff, in a sense that the above statement applies. The plaintiff has to make out a prima facie case to survive such absolution, and this prima facie case actually that is required from the plaintiff will remain in a position that qualifies the granting of such absolution.